Welcome back to the video lecture on ASEAN state practice in the domestic implementation of international law. This time, we are going to discuss the matter of implementation of ICCPR, the civil political rights in ASEAN. The following section addresses the key issues in ASEAN practice regarding the implementation of CPRs and SERs, considering the influence of the ICCPR and ESCR, the way applicable in affecting the national implementation of human rights norms. The civil political rights enjoy the constitutional and legal guarantees in ASEAN states, many of whom are also state parties to the ICCPR. Through the problems with the effective implementation existed. Article 19 of the ICCPR guarantees the freedom of expression, which is widely recognized in ASEAN constitutions as a liberty, important to all, regardless of culture and history. This is subject to limitation in the form of public goods such as national security, the rights of others, and reputational rights. The laws against the blasphemy and sedition have been deployed to severely curtail the express freedoms in Malaysia, Cambodia, Bhutan, and Brunei. Another example of the freedom of speech, for example, after 2006 Thai coup d'etat, the increasing resort to the draconian laissez-faire law under Section 112, the Thai Penal Code was evident, deployed against the political protesters. The chilling effect is evident in the disproportionate sentences involved, such as the 43-year imprisonment sentence against Angkang Pele in 2021 for reposting the video clips concerning the Thai democracy. In authoritarian social regime like China and North Korea, the free speech guarantees are in practice severely curtailed, as where political dissidents end up in North Korea, the re-education prison camp. Within the confines of the government-controlled forums, the Chinese government tolerates criticism insofar as this helps in monitoring social problems. It is instructive to refer to Asian state practice in evaluating the question of whether general international law prohibits death penalty, as the law and practice of many Asian states like China, Japan, India, Indonesia retain capital punishment, whereby hanging, the firing squad, and lethal injection, the stoning, or decapitation. In other Asian states, capital punishment have been constitutionally prohibited. Attempt to reinstate the death penalty has attracted widespread international criticism, as well as counter-allegations of intervention in internal affairs. 8 of the 41 sponsors delivering a February 2021 joint statement to the Human Rights Council declared that whether the death penalty should be retained was a sovereign state prerogative, where like the Asian states. Article 6.2 ICCPR provides that the death penalty should be reserved for the most serious crime. In ASEAN states, legislatively specified categories of crime attracting the death penalty include aggravated murder, terrorism, related offenses, homosexual sex, kidnapping, human trafficking, treason and espionage, and carrying firearms, for example. The Singapore, Malaysia, Indonesia, and China include grave drug trafficking offenses within that category. The several ASEAN states like Brunei, Laos, Republic of Korea, and Sri Lanka have an official moratorium or have not had executions for more than 10 years. As of 2021, some 88% of the all recorded executions took place in China. Let me touch upon the other issues like religious freedom and state religion models in Asia. Many Asian constitutions manifest a strong affiliation with religions, where ethnicity and religion are essential to the identity of their citizens. The constitutions of the Muslim and Buddhist majority societies like Malaysia, Brunei, Cambodia officially recognize Islam and Buddhism. In many secular ASEAN states, religions play a significant role in the public sphere, where religious values inform the lawmaking process and conceptions of justice. Religious freedom is limited in atheistic socialist states like China, where religious organizations as ideological competitors are subject to legal regulation. International guarantees of the religions the freedom to protect the internal right to adopt or change a belief based on the free conscience, which is absolute, and the rights in public or private, individually or and collectively, to manifest religious practice and testing peaceful without fear. This may be regulated by law to protect public safety, order, health, or morals, or the rights of others. The religious freedom is truncated by restrictive, the apostate, the law in Malaysia, and the anti-conversion law in India, the Sri Lanka, Nepal, and Myanmar and Bhutan, where the politically dominant religious majority perceive the religious minorities as a threat. The anti-propagation law typically prohibits religious conversions by force, the fraud, or the inducement. There is a tendency for these laws to be abused to further political agendas, for example, to serve Hindu-Buddhist nationalism, undermining the freedom to impart religious information and seek to persuade others to believe. Such legislation may apply to general or specific sectors of the population, as in Malaysia, where the Article 11.4 of the Federal Constitution prohibits the propagation of the other religious doctrine to Muslims, while the federal government supports the assimilation efforts to propagate the Islam to the indigenous peoples. The selective preferential treatment of the religion or religious sect is reflected in the criminalization of the case in Pakistan. The manifestations of the religious belief may be expressed by the wearing religious symbols, which states have limited in public spaces like schools, and preserve the social cohesion or national identity. The Malaysian federal courts upheld the constitutionality of a regulation prohibition male Muslim students from wearing the turban, like an Islamic turban, the balancing the religious freedom against national cohesion concerns, differing to education authorities, and the fact that wearing turban was considered not mandatory, but an optional aspect of Islam. It apparently applied to reasonableness balancing approach, noting the ban was not absolute, but applicable only within the schools. That turban could be worn in school prayer rooms, that there were schools which permitted turban wearing, and that prohibition stems from the desire to promote multiculturalism. The right to manifest one's religion or belief is limited by various domestic laws, such as sedition and the criminal offense of inciting religious or racial hatred or violence. Malaysian courts have upheld national security restrictions on a Catholic publication utilizing the word Allah to avoid disrupting the even tempo of the life of the Malaysian community. The blasphemy law does not protect religious freedom, but rather protect the majority of dominant religion, often detrimentally exposing religious minorities to physical violence from a hostile majority, for example, in a case of Pakistan and Indonesia. The further religious insult law may sharply limit expressive freedoms, as where an Indonesian artist was imprisoned in 2012 for stating God does not exist on his Facebook page. The issue of the non-discrimination and private claims framed as LGBTG rights has achieved prominence in constitutional and international human rights discourse, but remains controversial globally and in Asia. These implicate a range of issues, from attempts to decriminalize the homosexuals acts, campaigns to alter public sexuality education, and initiative to have same-sex relations legally recognized. This state practice about LGBTG is decisively split, and there is a little or no consensus regarding these politically sensitive issues over contested rights claims. The examination of the judicial attitude toward this issue reveals a diversity of views and approaches. While Indian Supreme Court, for example, held that the law against unnatural offenses, including carnal intercourse against other of the nature with any man and woman or animal, was unconstitutional on ground of equality and personal liberty in affirming the cult of egalitarian liberalism. And also Singapore Court of Appeal has apparently related but distinct law prohibiting the homosexuals act of gross indecencies on the basis of public immorality. Public floggings have been carried out in Aceh, Indonesia, and in Malaysia, where Islamic law prohibits sodomy and lesbianism. Various ASEAN jurisdictions may recognize the LGBTQ rights in relation to same-sex relations, and the Thai House of Representatives, for example, is reviewing the possibility of recognizing the same-sex marriage and the civil partnerships, while Japan's district court found the prohibition against same-sex marriage was unconstitutional. The prospect of such civil claims is impossible where homosexuals' conduct is criminalized, for example, such as Singapore, Malaysia, Brunei, and Bangladesh. Thank you very much for your very kind attention.